We're going to talk now to Francis Hall, public law barrister. Story yesterday that the Free Speech Union were able to brag about. They said this: "We're delighted the Bar Standards Board has dropped its proposal to impose a duty on barristers to promote, in their words, equality, diversity and inclusion." The Free Speech Union raised concerns, but they weren't the only people that did raise concerns. But they commissioned a 23-page legal opinion from leading public law barristers. And so more good news for those of us who think that the whole DEI propaganda campaign is on its last legs. Let's hope it is. Francis, a very good morning to you.
Morning, Mike.
Good to speak to you. I think people have been increasingly concerned at the creeping leftism, if you like, of the judiciary in this country. You know, there was a time, and I'm not saying it was necessarily better, when, you know, the old judges had to be reminded who, you know, George Michael actually was, because they didn't know very much about popular music. There was a time when, you know, they were more likely to be in the newspapers because of, you know, some perhaps nefarious activities they got up to in a basement in Soho. Whereas now they all seem to be straight out of, some kind of United Nations school of left-wing maniacs. And it's hard to find barristers these days who are not left-wing.
I don't know. I think perhaps barristers specialising in public law who are more likely to comment on political matters might be more likely to be left-wing. Do you want to talk about the proposal, Mike?
Yes, the Bar Standards Board had a proposal, which is kind of what leads me to ask that question, because the Bar Standards Board, I presume, is a regulatory body which regulates all barristers, but it wanted there to be a special promotion for equity or equality, diversity and inclusion.
So first of all, the Bar Standards Board was set up relatively recently as an independent body which has a majority of lay members, i.e. non-barristers and judges. The Bar Council is technically still legally responsible for regulation of barristers, but it delegates it to the BSB. The Bar Council, for what it is worth, has been opposed to this proposal throughout, and it comes from the BSB, and I think it comes because this is becoming a more general requirement in many areas. I think I agree with you wrongly, including in the solicitor's profession. And the current situation is, because quite apart from anything else, barristers have to follow the law in giving legal advice or doing anything else, that they cannot discriminate. And that is set out, cannot discriminate on the basis of protected characteristics. That's the Equality Act. Essentially, you give the same person a service to everyone, regardless of their sex, their race, whatever else it might be. And that's absolutely right. But this duty is a positive duty to promote equality, diversity and inclusion, which has a definition that is nowhere in law and is frankly a bit nebulous as to what that means. And the particularly difficulty there with that particular duty that was proposed is it's a positive duty. Now, there are some positive duties that barristers have obviously, such as to prepare for their cases, such as to work diligently for their client, but they're pretty unusual. Generally speaking, the duties are negative duties. So the duty not to discriminate is a classic one, and that's the appropriate way in which professions should be regulated, not to be negligent, to perform, now obviously that means performing a reasonable professional service. So in a sense, it's positive, but generally speaking, negative. This one means that if you don't do particular things, if you don't actively promote this, whatever that might mean, then you're somehow in breach of your duties. So you might think that you're going to do a profession and you represent your clients. You do as much or as little as you wish. We're self-employed, so you can do as much as little or as little as you wish work. But obviously all the work you do must be done conscientiously and well, and that's it. And providing you don't discriminate, that's fine. You shouldn't have those sort of positive duties. So that's one element, but there's an even worse element, which is a duty to promote outcomes that is measurable by means of the diversity of the population. Now, as Tom Grayson Coppell and Tom Cross, KCKC, put in that opinion, which is excellent and I recommend, that potentially imposes a duty on chambers to improve, in the words of the BSB proposal, measurable outcomes, i.e. potentially, if you aren't increasing the proportion of ethnic minorities or women or whatever it might be in your chambers, you're in breach of that. Well, it may well be that they're simply not applying to your chambers, or you're a small chambers, and therefore you can't possibly have a measurable, diverse outcome of people, because you're dependent upon who goes into that profession and who wants to go to chambers. We're not like huge organisations where you would expect to have some kind of diversity measurable by the population simply because of the great numbers of employees. It's a totally different profession.
No, of course. I mean, the other thing that's interesting in what the Free Speech Union had to say is that they also regarded this proposal as potentially having what they call a chilling effect on representation for clients with dissenting views, i.e. If people were coming to a barrister who was involved in this promotion of equality, diversity and inclusion, who was perhaps considered to be right-wing, or who might be considered to be someone who didn't think anything of those kinds of promotions, that they might not be fairly represented, or they may not be represented at all.
And indeed, you might have an employment tribunal case, or a case, a disciplinary regulatory body case, where somebody is being prosecuted or not prosecuted, but somebody's being dismissed or being disciplined for exposing those views, or a criminal case where they're prosecuted under various speech, effectively speech laws, such as Section 5 of the Public Order Act. Now, the reality is that if you didn't represent that client, if you didn't accept those instructions, if you were willing, if you were able to do the work, and there was a reasonable fee for the work, that's the cab rank principle. You have an obligation to do that irrespective of the views or the opinions of the individual, and to put their case forward conscientiously. You'd have a duty to do that still, which just shows that this duty, obviously not now being imposed, fortunately, is completely in conflict with the ethics and the ethos of the bar, as well as the ethics and the ethos of free speech. But the bar is there to ensure that everyone has the right to a representative of their choice, if they are able to provide, if they are able to source that representative, and that representative's available. That's a very important part of what this profession is about, and it feeds into free speech, because you can't be more free, and you should never be more free than when you're in court advocating on behalf of your clients. You should never be clipped or culled or have any kind of regulatory pressure over you when you're doing that, providing, of course, you don't mislead the court, and you keep to the acceptable standards of behaviour. That's essential.
Absolutely. And just one final, just a sort of addendum to all of that. I see from the front page of the Telegraph today, Sir Keir Starmer has been dragged into a legal battle over the burning of the Quran. Because it turns out that the lawyers will use a case successfully brought by Sir Keir more than 20 years ago, presumably when he was a human rights lawyer, in defence of Hamet Koskan, who is up before the Beak today, Westminster Magistrates Court, for behaviour likely to cause harassment, alarm or distress. So that'll be kind of interesting if Keir Starmer's previous victory is a factor in this guy getting off.
Yeah, very interesting, but it's very concerning, because in fact, my view is that that offence, Section 5 of the Public Order Act, which was introduced by the Thatcher government in the 1980s, is wrong and should be repealed. Causing somebody who may be doing behaviour that might cause somebody harassment and alarm or distress, in my view, does not pass the criminal threshold at all. And people need to be robust, and it's particularly important in terms of the expression of free speech. Now, the courts have reduced the effect of that section by saying that you have to respect Article 10, you have to respect free speech rights, and you have to respect Article 9, the right to a conscience and to manifest your religious and your beliefs, and that's important. But what's particularly important is when you're expressing your religious beliefs. Now, I can see that there may be circumstances where you are likely to cause public disorder and violence by, say, burning the Quran. And there may be circumstances, I don't rule out that there may be circumstances that might be a criminal offence. But in principle, exhibiting your religious views, even your religious hostility, and your hostility for other religions is an essential right, and it's very important it's respected. And it's very dangerous when we see members of the House of Commons talking about protections needed for Abrahamic religions, by which they probably mean one Abrahamic religion in particular. But in any event, Keir Starmer, when that question was asked by one of his backbenchers, did not say anything about the fact that we don't have a blasphemy law in this country. And if you come to this country and you live in this country, of whatever religion, you have to expect that your religion will be denigrated, will be ridiculed. We are not in the 16th or the 17th century anymore.
Yeah, absolutely right. Great to see you. Francis, thank you very much indeed. Francis Hall, public law barrister there.